So here's the recording of LLB semester 3rd Professional Ethics Accountability Lawyers Bar Council. Book is unique, primarily recording for self-study purpose. Okay, so very short answer type questions. Professional ethics. Explain the beginning and the development of legal profession in India with reference to Charter of 1774. Charter means Act of 1774. Regulating Act 1773 and the Charter of 1774 contributed a lot in the field of legal profession in India. The British Crown issued a charter in 1774 by which Supreme Court of Judicature was established at Calcutta. Clause 2nd of the Charter empowered the said Supreme Court at Calcutta in Bengal to approve and enroll advocates and attorneys at law. The term advocate then extended only to English and Irish barristers and members of the Faculty of Advocates in Scotland, and term attorneys then meant only the British attorneys and solicitors. Okay, so attorney was related to British attorneys and advocate was related to English and Irish barristers and members of the Faculty of Advocates in Scotland. However, attorney was only limited to British attorneys or solicitors. Even this Charter of 1774 did not provide for the appearance of the Indian legal practitioners to appear and to plead before the Supreme Court. In the Supreme Court at Bombay and Madras, also only the British barristers, advocates, attorneys were eligible for practice and not the Indian legal practitioners. Explain the development of legal profession with reference to Bengal Regulation Act of 1793. So first answer which we read related to explain the beginning and development of legal profession in India with reference to the Charter of 1774. So Indians were not allowed to present before Supreme Court at Calcutta. Only advocates and attorneys were allowed. Advocates related to English and Irish barristers, Scotland. However, attorneys were limited to British attorneys or solicitors. Now, explain the development of legal profession with reference to Bengal Regulation Act of 1793. So first we were 1774, now we have come to approx 20 years ahead in 1793. So what has changed in 20 years? 1793. The Bengal Regulation 7th of 1793 for the first time provided for the regulator legal profession for the company's code. Okay, first time provided for a regular legal profession for the company's code. Under this regulation, only Hindus and Muslims were entitled to be enrolled as pleaders. However, the Bengal Regulation 12th of 1833, okay, means around 40 years later, provided that any qualified person of any nationality or religion was entitled to be enrolled as a pleader of the Sadar Diwani Adalat. Sadar Diwani Adalat. The Legal Practitioners Act of 1840. So 1840, which is okay, from compared to 1973, 1840, so 1833. So we are 7 years ahead. 40 years ahead means from very starting 1774 to 20 years ahead. Then we were 40 years ahead. Then only in next 7 years, 1840, 1840, further provided that the Legal Practitioners Act 1840 further provided that the people of any nationality or religion would be eligible to act as pleaders. Okay, so this is answer to explain the development of legal profession with reference to Bengal Regulation Act 1793. So first in the starting only Muslim and Hindus were pleaders, and then others were slowly enrolled over next 7 years or so. Then people of any nationality or religion could be pleaders, and this was before Sadar Diwani Adalat. Explain the development of legal profession with reference to Legal Practitioners Act 1879. So 1879 is further, now we are further ahead 39 years. Okay, so now we have 39 years from 1840 to 39 years up we have 1879 where we have Legal Practitioners Act. So now we are discussing the development of legal profession. Legal Practitioners Act 1879 was enacted to consolidate and amend the law relating to legal practitioners. It provides that an advocate or vakil on the roll of any high court or a pleader of the chief court of the Punjab can practice in all courts subordinate to the courts on the roll of which he was entered. Okay, so here we found that on the rolls of any court in which he was enrolled, he can practice on all lower courts. So, vakil or advocate was allowed to practice on all lower courts than the court in which he was enrolled. The Charter of High Courts framed rules by which, apart from attorneys, there were advocates and vakils. Okay, so one word is attorneys, then another word is advocate, and another word is vakils. Advocates were to be barristers of England or Ireland or members of faculty of advocates of Scotland. So advocates were from England, Ireland, Scotland. The High Court, excluding the High Court of Calcutta, provided for enrollment as advocates to non-barristers under certain conditions. So, apart from High Court of Calcutta, other High Courts allowed non-barristers to enroll as advocates. In Bombay, the law graduate from Bombay University was eligible to be enrolled as advocate. So, in Bombay, law graduate from Bombay University was eligible to be enrolled as advocate. Explain the development of legal profession with reference to Indian Bar Committee 1923. So now from 1800s era we have come to 1900s era. In 1800s also last we saw Legal Practitioners Act 1879. So now 1879 to 23, that is around again 40 plus years, 44 years ahead. So around 40 more years, 1923, we have Indian Bar Committee. So now what is the development of legal profession in reference to Indian Bar Committee 1823? A committee called Indian Bar Committee was constituted in 1923 under chairmanship of Sir Edward Chamier. It was to consider the issue as to the organization of bar on all India basis and establishment of all India Bar Council for the High Court. Okay. However, the committee did not favor the establishment of all India Bar Council. Okay, so committee did not favor establishment of All India Bar Council. It was of the view that a bar council should be constituted for each high court. The committee suggested that in all high courts a single grade of practitioners should be established and they should be called advocates. Okay, it also suggested that on fulfillment of certain conditions, vakils should be allowed to appear on the original side of three courts at Bombay, Calcutta, and Madras. So these were the developments that All India Bar Council was considered to be established, and bar councils at each high court was viewed as better idea. Then it was suggested that practitioners, a single practitioner's grade of advocates be allowed. We will not have different names, barristers, advocates, vakils. So advocate was allowed, and certain vakils were allowed or from original side of three courts of Bombay, Calcutta, and Madras. Explain the development of legal profession with reference to Indian Bar Council Act 1926. So this one, what we just discussed was 1923. 1923 and up we have 1961. So from 20s to 60s. So around 44 more years forward. So we are 40 more years forward. What are the kinds of legal practitioners before passing the Advocate Act 1961? So before passing this act, Advocates Act 1961, in 40 more years, What was the kind of legal practitioners? It is evident that prior to 1961 there were different kinds of legal practitioners in India, that is advocates, attorney at law or solicitors, then we have pleaders, then we have wakils, and then we have mukhtar, and they were registered and enrolled under various legal practitioners acts. So under various legal practitioners act they were registered. We had advocates, attorney at law, which were solicitor, pleader, wakil, and mukhtar. Pleader, wakil, mukhtar. Pleader, wakil, mukhtar. Advocate, attorney at law, that is solicitor. Advocate, solicitor, attorney at law, pleader, wakil, mukhtar. It was only in 1961 that all classes of legal practitioners were consolidated and amalgamated into one class, and that the category of advocates, and they all are called now advocates. So this has happened in 1961 after passing of the Advocates Act of 1961. Now there is only one legal practitioner act for the whole of India, that is the Advocates Act 1961. The other acts known as the Legal Practitioners Act 1879, the Bombay Pleaders Act 1920, the Indian Bar Council Act 1926, and the Supreme Court Advocates Act 1951 were repealed. So all existing other various practitioner act were repealed, which were Legal Practitioners Act 1879, then Bombay Pleaders Act 1920, Indian Bar Council Act 1926, and Supreme Court Advocates Act 1951. These were repealed in 1961, and only single Advocates Act was established to take over advocates, attorney at law, solicitor, pleader, wakil, mukhtar. Next is, what do we mean by an advocate? So who is an advocate? What do we mean by an advocate? According to section 2 subsection 1 subsection A, advocate means an advocate entered in any role under the provisions of the act. So this is the first definition. So that is why 2 subsection 1 and subsection is A, and usually definitions are alphabetically. So A stands for advocate, means an advocate entered in any role under the provisions of this act. What do we mean by appointed day? According to section 1 subsection 1 subsection B, in relation to any provision of this act means the day on which the provision comes into force. So appointed day is the day when the provisions come into force. What do we mean by State Bar Council? According to section 2(1) subsection D, State Bar Council means Bar Council constituted under section 3 of the Advocates Act 1961. So State Bar Council is Bar Council constituted under section 3 of the Advocates Act 1961. What do you mean by Bar Council of India? According to section 2 subsection 1 subsection E, Bar Council of India means the Bar Council constituted under section 4 of the territories to which this act extends. Okay. So Bar Council of India means the Bar Council constituted under subsection 4 for the territories to which this act extends. For all territories is Bar Council of India. State Bar Council is constituted under subsection 3 of the Advocates Act 1961. Subsection under section 3 is relating to State Bar Council, and section 4 is relating to Bar Council of India. What do we mean by the law graduate? A person who has obtained a bachelor's degree in law from any university established by law in India. So, a person who has obtained bachelor's degree in law from any university established in India is called law graduate. Okay, so that person is called law graduate. Next, we move to, what do we mean by legal practitioner? According to section 2 subsection 1, legal practitioner means an advocate or wakil of any high court, a pleader, mukhtar, or revenue agent. So legal practitioner is encompassing advocate or wakil. Advocate or wakil can be used synonymously, of any high court, or a pleader or mukhtar or revenue agent. All these are legal practitioner. Revenue agent is a legal practitioner, mukhtar is a legal practitioner, pleader is a legal practitioner. What do you mean by role? According to section 2 subsection 1 and subsection K, roll means a roll of advocates prepared and maintained under the act. Roll means roll of advocates prepared and maintained under the act. What do you mean by state roll? According to section 2 subsection 1 subsection N, state roll means a roll of advocates prepared and maintained by the State Bar Council under section 17. State roll means roll of advocates prepared and maintained by a State Bar Council, and that is maintained under section 17, maintained by State Bar Council, that is state roll, and rest roll under section 21K is roll of advocates prepared and maintained under the act. These are only rules, and state rules are under section 17 of uh, roll of advocates prepared and maintained by state bar councils. What do you mean by barristers? The degree of barrister could only be conferred by an Inns of the court, and its possession was recognized by the judges as a necessary qualification without which no one could practice as an advocate in the court. So without this, no one could practice as an advocate in the court, and it is given conferred by the Inns of the court, and its possession is recognized by the judge as a necessary qualification. The right of practicing as counsel in England and Wales has traditionally been reserved for barristers. So rights of practicing as counsel in England and Wales. In England and Wales, if you want to practice, then you should be a barrister. What are the two kinds of advocates and who is a senior advocate? Okay, two kinds of advocates and who is a senior advocate. So Advocates Act 1961 provides for two classes of advocates, namely senior advocates and advocates. According to this section, an advocate may, with his consent, be designated as senior advocate if the Supreme Court or High Court is of opinion that virtue of his ability he is deserving of such distinction. So High Court or Supreme Court is of the opinion that an advocate is deserving of such an distinction, then and with his consent only he can be designated as senior advocate. According to section 16 subsection 3, senior advocates shall in a manner matters of their practice be subject to such restrictions as the Bar Council of India may in the interest of legal profession prescribe. Okay, in the matter of their practice be subject to such restrictions as the Bar Council of India may in the interest of legal profession prescribe. So there may be certain restrictions also. Section 16 subsection 4 provides that an advocate of the Supreme Court who was a senior advocate of the court immediately before the appointed day shall for the purposes of this section be deemed to be senior advocate. Okay, so before coming into effect of this act, the Advocates Act 1961, if any advocate of Supreme Court was a senior advocate immediately before the appointed date, that is coming into effect of Advocates Act 1961, then he shall be deemed to be a senior advocate who may be admitted as advocates on a state roll. So on a state roll, who may be admitted as an advocate? According to section 2 of the Advocates Act 1961, subject to the provisions of this act and rules made thereunder, a person shall be qualified to be admitted as an advocate on a state roll if he fulfills the following conditions, namely, so he must be a citizen of India, provided that subject to other provisions contained in this act, a national of any other country may be admitted as an advocate on a state roll if citizens of India duly qualified are permitted by law in that other country. Okay, primarily he should be citizens of India. However, if he is from any other country where Indian citizens are allowed to be on their duly qualified, are permitted by law in other countries, then that other country's person can also be advocate on state roll in India. He has completed the age of 21 years, so minimum age criteria is 21 years. He has obtained a degree in law. Degree in law is mandatory. He fulfills such other conditions as may be specified in the rules made by the State Bar Council under this chapter. So there may be rules by the State Bar Council. He has paid in respect of enrollment stamp duty, if any, and chargeable under the Indian Stamp Act, and an enrollment fee payable to the State Bar Council 600 rupees, and to the Bar Council of India 150 rupees by way of bank draft drawn in favor of that council. So he has made payment of enrollment fees plus stamp duty under Indian Stamp Act 1899. Indian Stamp Act is in 1899, very old, in 80s, 1800s, almost last section. 1899, last year, almost last year, 1899. Then next will come 1900. So Indian Stamp Act is 1899, and an enrollment fee payable to the State Bar Council is 600 rupees. So how much is enrollment fees payable? 600 rupees. This is paid to State Bar Council and to Bar Council of India, and fee is paid of 150 rupees by way of bank draft drawn in favor of that council. Whether Bar Council of India can debar a person from enrollment as an advocate who has completed the age of 45 years. So whether Bar Council can debar a person from enrollment as an advocate who has completed age of 45 years. My answer is no. Let's see. The Bar Council of India is not empowered to make the rules on the basis of age factor for enrolling the advocates. In case of Indian Council of Hmm. Legal Aids and Advice versus BCI and others, Year 1995 Supreme Court. The Supreme Court has made it clear that the rule debarring a person who has completed the age of 45 years is beyond the rule making power of Bar Council of India. So, Bar Council cannot restrict the age to 45 years, and the case law relating to this is Indian Council of India, Indian Council of Legal Aid and Advice versus BCI and others, year 1950, 1995. Okay. Whether Bar Council of India Training Rules 1995. Okay. So let's finish this here. Question number 19. Whether Bar Council of India Training Rules 1995, providing certain preconditions to be complied with by an applicant to be enrolled on the roll of State Bar Council, are valid. So whether Bar Council of India Training Rules, providing certain preconditions for enrollment on State Bar Council, are valid. So whether Bar Council of India applies certain rules for State Bar Council enrollment, is it valid? This is the question. And these are rules of 1995. So now last we were at 1995, there was a case, and last we were at Advocates Advocates Act 1961. Okay, so from 1961 we have jumped to 1995, 61 to 95. So this is around 35 years. So now earlier we were jumping 20 years or so, or 40 years or so, and now we have jumped around 35 years or so to 1995. So it was held by the Supreme Court that the impugnant training rules 1995 are invalid and illegal and quashed. It was further clarified that this judgment will operate only prospectively to avoid unnecessary confusion and complications. It was further made clear that because of the questioning of impugnant rules, only applicants who apply for the first time for enrollment after the date of the present judgment will not have to undergo pre-enrollment training. So these rules have been made invalid, illegal and quashed. However, this decision is only relating to prospective trainings. So Bar Council cannot require certain preconditions for enrollment of State Bar Council. These were Bar Council rules 1995. Now next we are approaching whether the enrollment of a person carrying other profession can be restricted. So question 20 is whether the enrollment of a person carrying other profession can be restricted. So if a person is practicing another profession, then can he be enrolled or not enrolled? So answer to question number 20 is, as regards the enrollment of a person already carrying on other profession as advocate, the Bar Council of India or the State Bar Council may make rules restricting or debarring such person from being enrolled as advocate. In case of Haniraj L. Cholani versus Bar Council of Maharashtra and Goa, Year 1996 Supreme Court, the Supreme Court has held that the rule made by the Bar Council restricting the enrollment of person as an advocate under the Advocates Act 1961 already carrying on other profession is not arbitrary and therefore does not violate provisions of Article 14 of the Constitution. So yes, it can restrict other professionals from enrolling as advocates both for Bar Council of India and for State Bar Council, and this was held in case of Haniraj L. Chulani. Haniraj L. Chulani versus Bar Council of Maharashtra and Goa, year 1996. So this is 1996. Okay. This is not arbitrary, and accordingly this is not in violation of provisions of Article 14 of the Constitution of India. Question 21 is, to which authority application for enrollment as an advocate may be made? So to which authority an application for enrollment as an advocate may be made? According to section 25, an application for admission as an advocate shall be made in the prescribed form to the Secretary State Bar Council within whose jurisdiction the applicant proposes to practice. So within whose jurisdiction applicant proposes to practice, then to that Secretary State Bar Council application will be made by an advocate to practice, and there will be a prescribed form which needs to be filled, and this is provided in section 25. Okay, section 25 of the Advocates Act 1961. What is the procedure for disposal of the applications for enrollment as an advocate? So what procedure will be followed after an application is received? So answer to question 22 is, according to section 26 subsection 1 of the Act, the Advocates Act 1961, a State Bar Council shall refer every application for admission as an advocate to its enrollment committee, and subject to the provisions of subsection 2 and subsection 3 of section 26, and to any direction that may be given in writing by the State Bar Council in this behalf, such committee shall dispose of the application in the prescribed manner. So every application which is received shall be disposed of in a prescribed manner. First, it will be forwarded to an enrollment committee. Enrollment committee will follow the directions given by State Bar Council. Enrollment committee shall follow the provisions provided in subsection 2 and subsection 3 of section 26 of the Act. And that is how every application for becoming an advocate shall be disposed of by the enrollment committee. What are the disqualifications for enrollment as an advocate? According to section 24A of the Advocates Act, Advocates Act is 1961. So according to section 24A of the Advocates Act 1961, no person shall be admitted as an advocate on a state roll if he is convicted of an offence involving moral turpitude, if he is convicted of an offence under the provisions of Untouchability Act 1995, provided that the disqualification for enrollment as aforesaid shall cease to have effect after a period of 2 years had elapsed since his release or dismissal, or as the case may be, removed. So in case of moral turpitude, if he is convicted, then no chance. If under the provisions of Untouchability Act 1995, then also chances after 2 years of removal of such disqualification, and if he is dismissed or removed from employment or office under the state or any charge involving moral turpitude. So, if he is dismissed or removed from employment or office under the state or any charge involving moral turpitude. So, if such is the case, if he is removed from employment, then also his admission will not be allowed. Nothing contained in subsection 1 means subsection 1 of section 24A shall apply to a person who, having been found guilty, is dealt with under the provisions of the Probation of Offenders Act 1958. So now if any person is found guilty, then that will be dealt with as per provisions of Probation of Offenders Act 1958. 1950 means this Probation of Offenders Act 1958 came before the Advocates Act 1961. It came around 3 years prior to Advocates Act 1961. Probation of Offenders Act. If provisions are applicable, he is found guilty under this Probation of Offenders Act, then that will prevail. Otherwise, no person shall be admitted on state roll. This is specifically for state roll. If he is convicted for moral turpitude, or if it convicted under Untouchability Act for 2 years and has not been passed, and his employment is dismissed or he is removed from employment or office under the state. So he is removed from employment under the state and is, or he is removed from any employment or office for any charges involving moral turpitude. So he is not convicted, but he is removed for moral turpitude from any office. Then also he cannot become, or if he is removed by a state, then also he cannot become. And if Probation of Offenders Act is applicable, then that act will prevail. Terms and conditions of that act will prevail. This related to enrollment on state list, state count bar, enrollment on state roll. Okay. So next we move to question number 24. So on page 6, question 24 is, how is a dispute regarding the seniority settled? So according to section 21, this section 21 is of the Advocates Act 1961. So according to section 1 of Advocates Act 1961, according to section 21, where the date of seniority of two or more persons is the same, the one senior in age shall be reckoned as senior to the other. According to subsection 2, subject as aforesaid, if any dispute arises with respect to seniority of any person, it shall be referred to State Bar Council concerned for decision. So if there is a dispute as to seniority, then both senior persons will be adjudged on the basis of their age, and if still it cannot be adjudged, then it will be referred to State Bar Council. Who is to maintain role of advocates? So this role of advocates, who will maintain? According to section 17 subsection 1, every state bar council shall prepare a roll of advocates in which shall be entered the names and addresses of all persons who were entered as advocates on the roll of High Court under the Indian Bar Councils Act 1926 immediately before the appointed date, including persons being citizens of India who before the 15th day of August 1947 were enrolled as advocates under the Act in any area which before the said date was comprised within India as defined in the Government of India Act 1935, and who at any time express an intention in the prescribed manner to practice within the jurisdiction of Bar Council. So maintaining, regarding who is to maintain role of advocates. So according to section 17 subsection 1 of the Advocates Act 1961, every state bar council shall prepare a roll. So who shall prepare a roll of advocates? Every state bar council shall prepare a roll of advocates. And in the roll, what will be entered? In the roll, they will enter name and addresses of all persons who were entered as advocates on the roll of High Court under the Indian Bar Councils Act 1926 immediately before the appointed day. Appointed day means when this Act, Advocates Act 1961, came into force, became effective. So, on that roll, all the advocates who were advocates on the roll of High Court, they all will be entered. And what will be entered? Their names and addresses will be entered. And they will be entered as advocates, and also who at any time express an intention in the prescribed manner to practice within the jurisdiction of bar council. So those who give an intention that they wish to practice, then those will be entered. So we will, in the roll, we will enter names of all those prior advocates, their names and addresses who were on the roll of High Court, and then all those who express their intention in the prescribed manner, means those who will fill the prescribed form, shall be entered in the roll of Bar Council, State Bar Council. What are the rights of advocates? So, according to Section 30 of the Advocates Act, subject to the provisions of this Act, every advocate whose name is entered in the state roll shall be entitled as of right to practice throughout the territory to which this Act extends. So, every advocate who is on the roll of state roll shall be entitled, he has right to practice throughout the territory to which this act extends, means throughout the territory to which this Advocates Act 1961 extends. This is provided in section 30. If once he is enrolled in any state roll, then he can practice in any territory to which this Advocates Act 1961 extends, in all courts including Supreme Court. So he, once enrolled, he can practice in all courts before any tribunal or person legally authorized to take evidence. So any person who is legally authorized to take evidence, any tribunal which is legally authorized to take evidence, before that this advocate who is enrolled in any state role in any territory of India where this act extends can exercise. So, in the Supreme Courts, in all the courts, including Supreme Courts, before any tribunal or legal person authorized to take evidence. Then, third is before any other authority or person before whom such advocate by or under any law for the time being in force entitled to practice. Before any other authority or person before whom such advocate by or under any law for the time being in force is entitled to practice. So any other authority is also covered. All courts, including Supreme Courts, tribunals where evidence can be taken, or any other authority or person before whom such advocate under any law is entitled to practice. However, this section, which section? This section 30 of which act? Advocates Act. In which year? 1961. However, this Section 30 has not been brought into effect by the central government. Because of it, the advocates are being debarred from appearance in many tribunals, namely industrial tribunals, family courts, Juvenile Justice Act. As under these acts, a specific bar is provided against the appearance of the advocates in the acts itself. Okay, so this Section 30 is not brought into effect by central government, and therefore advocates are debarred from appearing before certain tribunals. For example, industrial tribunal. Why industrial tribunal? Because under the Industrial Tribunals Act itself, advocates are debarred from practicing. Another is Family Courts Juvenile Justice Act. Family Court Juvenile Justice Act. Here also, under these acts, specific bar is given on appearance of advocates. So then, advocates cannot appear before industrial tribunals and family courts because of specific bar prohibition given in these acts. And section 30 is not made applicable by the central government. If it were made applicable, then advocate enrolled with any state could appear before any court, Supreme Court, tribunal which can take evidence, any other authority. But because of this, Section 30 not applicable, not yet brought into effect. Law is there, but is not effective. Next question 27 is, what do you mean by the right of pre-audience? What do you mean by right of pre-audience? Okay, right of pre-audience. Section 23 of the Advocates Act. Before, let's go back. What we were discussing earlier was that advocates under state role by default under Section 30 could have practiced before any court. However, because central government has not made it applicable, so they cannot appear before certain tribunals. And this question related to rights of advocates. So that is how rights of advocates are restricted. Now, question 27 was, what do you mean by the right of pre-audience? Section 23. Above section was 30. This is section 23 of the Advocates Act 1961 provides in respect of right of pre-audience as follows. The Attorney General of India shall have pre-audience over all other advocates. So Attorney General shall have pre-audience over all other advocates. Subject to the provisions of subsection 1, the Solicitor General of India shall have pre-audience over all other advocates. Subject to provisions of subsection 1 and 2, the subsection 1 and 2 of section 23 of the Advocates Act 1961. So under section 23 itself, the additional Solicitor General of India shall have pre-audience over all other advocates. Subject to provisions of subsection 1, 2 and 3 of section 23 of the Advocates Act 1961, the second additional Solicitor General of India shall have pre-audience over all other advocates, and subject to the provisions of subsection 1, 2, 3 and 3A. 1, 2, 3 and 3 of which section? Section 23 of which Act? Advocates Act. Which year? 1961 Act. 1, 2, 3 and 3A. Subject to that, the Advocate General of any state, the Advocate General of any state shall have pre-audience over all other advocates, and the right of pre-audience amongst Advocates General inter se shall be determined by their respective seniority. So rights among them shall be exercised depending by their respective seniority. Subject as aforesaid, senior advocates shall have pre-audience over other advocates. Okay, senior advocates shall have pre-audience over other advocates, and the right of pre-audience of senior advocates inter se shall be determined by their respective seniority. So right of pre-audience of senior advocates inter se among themselves shall be determined by their respective seniority. So in this question, what do you mean by right of pre-audience? We understand that right of pre-audience means that advocates with higher ranks shall have first chance to be heard in any court. So as the rank means, if there is an advocate versus senior advocate, then senior advocate will get first chance to be heard. So this authority starts from top. Top is Attorney General of India, next is Solicitor General of India, next is Additional Solicitor General of India, next is Second Additional Solicitor General of India, next is Advocate General of any state, next is Senior Advocate, and then comes all other advocates. Let me repeat. At the top apex is Attorney General of India, then Solicitor General of India, then Additional Solicitor General of India, then Second Additional Solicitor General of India, then Advocate General of any state, then Senior Advocates, and then all other advocates. So in this answer, we understand that under section 23 of Advocates Act 1961, the sequence of right of pre-audience is Attorney General of India first at the top, then subject to provisions as already provided. After Attorney General will come Solicitor General of India, then subject to these 2 points, Next comes Additional Solicitor General of India, then subject to these 3 points. Next comes Second Additional Solicitor General of India, then subject to these 4 points. Next comes Advocate General of any state. Then next comes uh, Senior Advocate, and finally advocates. So this is the right of pre-audience. This is called right of pre-audience, means they have the right to be heard first in this sequence based on their seniority. Question 28. What are the powers and functions of Bar Council of India? So what all are the powers and what all functions do Bar Council of India perform? First is to admit advocates. Basic function is to enroll, admit advocates. Number two is to appoint committee and staff members. So Bar Council will appoint committee, okay, enrollment committee, and there may be other committees, enrollment committee and staff also are appointed by Bar Council. Then Bar Council will maintain accounts. Proper books of accounts will be maintained by Bar Council of India. Bar Council will make rules. Rules will be made. Punish for uh, professional and other misconduct. So if there is professional misconduct, then punishment will be given by Bar Council as per their prescribed rules. If there is any other misconduct other than professional, then also punishment will be given by Bar Council of India based on rules provided by them. The next is power is appellate power. Bar Council has appellate powers. So appellate powers will be there. Means some order is passed, then to appeal against. Appellate means appealable. Appeal powers. Appeal can be filed against certain orders. So it has appellate powers. And last is financial powers. Bar Council has financial powers. So what are the powers and functions of Bar Council? Admit advocates, appoint committee, appoint staff members, maintain accounts, make rules, punish violators, professional misconduct, other misconduct, appellate powers, financial powers. So these are powers and functions of Bar Council. Then what are powers and functions of State Bar Council? Question 29. Powers and functions of State Bar Council. So it also admits advocates on a state roll. They admit advocates on a state roll. Now can state roll advocates uh, act practice in any court? As per section 30 of Advocates Act 1961, yes, but central government has not made that applicable to all the states, so he cannot do so. And there are certain tribunals, industrial tribunals, family courts, juvenile act, where they are barred from practicing. So we are talking about powers and functions of State Bar Council: to admit advocates on state roll, to maintain roll of advocates, then this role will be maintained, to make rules, they will also make rules at their state level, to punish for professional other misconduct, they can also punish, to appoint committees and staff members, similar point, to appoint staff members, similar point, and to maintain accounts, they can also maintain accounts. So all these points are powers and functions are similar. Admit advocates is similar, that is in the state role. Then appoint committee and staff is similar. Maintain accounts is similar. Financial power is not written here, so that had financial power. Then appellate power is not written here, because if it's order against State Bar Council's order can be to Bar Council of India. Appellate appeal can be filed to Bar Council of India. So it can also make rules, it can also punish for professional and other misconducts, it will admit advocates, and it will maintain role of advocates. How the disciplinary committee of State Bar Council is organized? Section question 30. How the disciplinary committee of State Bar Council organized? Disciplinary committee. Section 9 of the Advocates Act 1961 requires the State Bar Council to constitute one or more disciplinary committees. So it will constitute one or more disciplinary committees as per section 9. Each of such committees required to constitute Each of such committees required to consist of 3 persons, of whom 2 shall be persons elected by the council from amongst advocates who possess the qualifications specified in the proviso subsection 2 of section 3 and who are not members of council, and the senior-most advocates among the members of the disciplinary committee shall be chairman thereof. So, what we understand is State Bar Council will constitute one or it may constitute many more disciplinary committees. Each disciplinary committee shall consist of 3 persons. Each committee will consist of 3 persons. 2 shall be elected by council from amongst the advocates. Okay, amongst the qualified advocates, 2 shall be appointed, and those 2 advocates should not be members of council, and the senior most advocate among members of a disciplinary committee shall be chairman. So in the appointed 3 persons, the one who is senior most shall be the chairman. Simple. One who is the senior most shall be the chairman. So 3 persons, 2 persons elected by the council from amongst advocate who possess the qualifications specified in the proviso to subsection 2 of section 3 and who are not members of council. So 2 shall be such who are not members of council and possess such qualifications. And senior most advocate among the members of the disciplinary committee shall be chairman thereof. I read this answer from somewhere else also, because I understand 2 are talked about in this answer, 1 is not talked about in this answer, and it is causing confusion. This is clear that 3 will be in each disciplinary committee. This is clear that chairman or chairperson would be the senior most person among those 3. But 2 and 1 is still causing confusion. What I read somewhere else was that 2 members are elected by council from among its members. Council's own members, 2 members are there, and 1 member is a person who possesses qualifications specified by Advocates Act, but who is not the members of the council. So 1 is not already existing members of the council and he possesses the qualifications, but 2 are already existing members of the council, and among these 3, senior most shall chair the disciplinary committee. Okay. So what is the procedure? Question 31. What is the procedure to be followed by disciplinary committee of State Bar Council? Procedure to be followed. Section 35 provides that where on receipt of a complaint or otherwise a State Bar Council has reasons to believe that any advocate on its roll has been guilty of professional or other misconduct, it shall refer the case for disposal to its disciplinary committee. So, if either on the basis of a complaint or even otherwise, either complaint is received by whom? Complaint is received by State Bar Council, or even otherwise on its own motion, by whatever way, even if no complaint is received, State Bar Council has reasons to believe that any advocate on its roll is guilty of professional or other misconduct, then it shall refer the case for disposal to its disciplinary committee. So, a professional, advocate, or is on its roll and is guilty or might be guilty of professional or other misconduct. Either state bar council has reasons to believe, or a complaint is received. So the matter will be referred to disciplinary committee for disposal. So this is the procedure to be followed by disciplinary committee of State Bar Council. This is the procedure. Disciplinary committee will receive from State Bar Council cases either based on complaint or its own reasons. What cases would be there? That certain advocates already on the roll of State Bar Council are or might be or is guilty of professional misconduct, or are or might be guilty of other misconduct. So this is the procedure followed by disciplinary committee of State Bar Council. Question 32. What are the powers of disciplinary committee of State Bar Council? What are the powers of the disciplinary committee of State Bar Council? So we are talking about now powers. Earlier was procedure. So first power is to dismiss the complaint or where the proceedings were initiated at the instance of the State Bar Council, direct the proceedings be filed. So it can direct that the proceedings be filed. Either it can dismiss the complaint or it will direct that further proceedings be filed. So case is referred by State Bar Council. Either on seeing the case it can dismiss the complaint as it is, or where proceedings were initiated at the instant of State Bar Council, then direct the proceedings be filed. If already certain proceedings are taken by State Bar Council, then it will be directed, State Bar Council will be directed to provide the proceedings, file the proceedings. Next is reprimand the advocate. So if an advocate is found guilty of professional misconduct or other misconduct, then then this disciplinary committee of State Bar Council can reprimand the advocate. Okay, only reprimand, like giving warning to the advocate. This can be done. Next power is suspend the advocate from practice for such period as it may deem fit. So first it will reprimand, then it may suspend the advocate from practice. And for how long suspension can happen? For any period as the disciplinary committee may deem fit. And lastly, remove the name of advocate from state roll of advocate. So suspension, the next is removal of name. So worst case is removal of name of advocate from state roll. Then earlier than that suspension can happen. Earlier than that only reprimand can happen. Before that complaint can be disposed of as it is, or if the any proceedings are initiated by State Bar Council, then it can direct that proceedings be filed. So these were the powers of disciplinary committee of State Bar Council. Next question 33 is, what are the powers of disciplinary committee of Bar Council of India regarding review? Powers regarding review. Section 44 is regarding review. Section 44 provides that disciplinary committee of Bar Council of India may on its own motion or otherwise review any order within 60 days of the date of that order passed by it. So if it has passed an order, then it can review that order within 60 days. It can review that order within 60 days, either on its own motion or otherwise. Means if the person advocate may request that the order be reviewed again, and the Bar Council of India, the disciplinary committee of Bar Council of India may review within how much time? Within 60 days from the date of passing the order, either on its own motion or otherwise. So these are the powers of disciplinary committee regarding review. Next question is 34. What remedies are available to an advocate aggrieved by an order made by the disciplinary committee of the State Bar Council? What remedies are available to an advocate aggrieved by an order made by the disciplinary committee? So it can ask for review or it can go for appellate tribunal to the Bar Council of India. Now here answer is, first option available is review applications to State Bar Council, review application to State Bar Council. Second is appeal to Bar Council of India, review application or appeal to Bar Council of India, review application to State Bar Council or appeal to State Bar Council. These are the remedies available to advocate who is aggrieved by an order of disciplinary committee of State Bar Council. Question 35. What remedies are available to an advocate aggrieved by an order made by the Disciplinary Committee of Bar Council of India? What remedies are available to an advocate aggrieved by an order made by the Disciplinary Committee of Bar Council of India? What remedies are available to an advocate aggrieved by order made by Disciplinary Committee of Bar Council of India? Okay, so means first was state. Against state, it could file review application or it could file appeal to bar council, but in case of bar council it do not have option of review application. It cannot file review applications to bar council of India. It can only file an appeal to Supreme Court. So against bar council of India it has only option if it is aggrieved, if an advocate is aggrieved by order of Disciplinary Committee of Bar Council of India, then it has only one option to file an appeal before Supreme Court, and it do not have review application option in front of Disciplinary Committee of Bar Council of India. Question number 36. What are the powers and functions of Bar Council of India? Now, powers and functions of Bar Council of India. Okay. So, powers: to admit persons as advocate. Similar, we have seen that. To admit persons as advocate. Number two, to appoint committees and staff members. Similar, we have read this already. To maintain accounts. Similar, we have already covered. To make rules. Similar. To punish professionals for professional other misconduct. Seems same question is being repeated or similar question is being repeated. Appellate powers. Yes, it has appellate powers. Other powers and functions, that is to give directions to State Bar Council. It can give direction to State Bar Council. This is additional. It can give direction to State Bar Council. Or what else it can do? Or what else? Or committee, to any committee thereof. Okay, so State Bar Council has committees like disciplinary committees, so it can give direction to State Bar Council or any committee thereof for the proper and sufficient discharge, or the function of committee for the proper discharge of the functions of state, and review its order within 60 days from the date of the order passed by it. So when we heard about review, we heard that either disciplinary committee can review on its own or otherwise. In otherwise, either professional may request, or means advocate may request, or otherwise also means that Bar Council of India require, direct, that certain order be reviewed, and that order will be reviewed within 60 days from the date of passing of the order by it. So Bar Council can also direct for the review of order. Plus Bar Council can also give certain other directions to give directions to State Bar Council or any of the committees of State Bar Council. So these are the powers and functions of Bar Council of India. Okay, so next we move to question number 37. What do you mean by professional ethics? What do you mean by professional ethics? Professional ethics is a code of conduct, written or unwritten, for regulating the behavior of an practicing lawyer towards himself, towards his client, towards his adversary in law, and towards the court. So how he will behave. A code of conduct for behavior. A code of conduct, whether written for behavior or whether unwritten, for regulating the behavior. Intention is to regulate. This is called professional ethics. Professional ethics is a code of conduct, written or unwritten, for doing what? For regulating the behavior of a practicing lawyer. Towards whom? Number one, towards himself. His act towards himself, how he is behaving towards himself, that is also matter of concern, because he is a professional. Okay, he is representing a professional, so he has to behave in a certain way even towards himself. Number two, towards his client. He is a professional, he is an advocate, he has to behave in a certain way, follow code of conduct towards his client. Then He has to follow certain code of conduct towards his adversary in law and towards the code. Finally, fourth is towards the code. He has some professional ethics, some behavioral requirements while practicing towards the code. So when he is practicing as lawyer, then he has to regulate his behavior as per code of conduct, which may be written, which may not be written. So while practicing, he has to follow, regulate a behavior towards himself, his client, his adversary, or towards code. Himself, his client, his adversary, or towards code. This is the meaning of professional ethics. Question number 38. What is the object of ethics of legal profession? Object. Why are there ethics at all? So the object of ethics of legal profession is to maintain dignity of the legal profession and the friendly relation between the bench and the bar. So between the bench and the bar, to maintain a friendly relation. This is the ultimate objective of having ethics of legal profession. We follow certain ethics to maintain friendly relation between bench and bar, to maintain dignity of legal profession. Question number 39. What is the necessity of code of professional ethics? What is the necessity of the code of professional ethics? The legal profession is necessarily the keystone of the arch of government. If it is weakened by allowing it to be increasing for subject to the corroding and demoralizing influence of those who are controlled by craft, greed, and gain, or other unworthy motives, sooner or later the arch must fall. So, the necessity of having a code of professional ethics is established that there might be certain people who are in control of the craft. They are very good at it, and they might get greedy and might want to gain, and or they might have some unworthy motive. So sooner or later, if they are not controlled, then it might even collapse the government system. Okay, people may lose even trust in the government system or even the legal system. So ethics help that such weight of government arch is maintained. So if it is weakened by allowing it to be increasing for subject to the corroding and demoralizing influence of those who are controlled by craft, greed, or gain, or other unworthy motives, sooner or later the arch must fall. So simple language, necessity is that to ensure everyone is in control, everyone is able to take care of their greed, gain, unworthy motive, craft, everything. Okay, everything is controlled and is done in a friendly and sociable manner. So that is why there is a need of code of professional ethics. Question number 40. What are advantages of the legal ethics? What are the advantages of legal ethics? Advantage. So, an advocate being a public functionary, anyone taking to practice at the bar should have a correct knowledge of privileges as well as of ethical obligations of the members of his profession. He should be able to distinguish between right and wrong in the matter of professional conduct without difficulty or hesitation. This is necessary for the satisfaction of his own conscience, for the honor and good name of the profession, for protection of client and other concerned in litigation, and for the welfare of general public. So, in simple language, we have many advantages of having legal ethics. First, one is very clear when there are well documented legal ethics, when it is very well written or unwritten or practiced or as custom prevails, when everyone is clear that this is right behavior, this is wrong behavior, then it becomes very easy to gauge things happening right. Okay, it is very necessary for own conscience, means I am clear that what I am doing is right, and if someone is not doing what is right, then that can be called out. For honor and good name of the profession, even this profession, from the people, from their cultural behavior, people are gauging whether this is a good profession or not. So for the honor and good name of the complete profession of law, this is legal ethics are important. For protection of clients, to ensure clients are not unduly solicited or anything happening. So even for clients protection, legal ethics are important. And concerned in the litigations, others, even apart from clients, others who are concerned in the litigations for their welfare, for the welfare of general public, for everyone, legal ethics are very important and very advantageous for everyone. So that is the importance of legal ethics, advantages of legal ethics. We can distinguish clearly right and wrong. Next, we move to question number 41. What is the nature of professional or legal ethics? Nature. Legal profession is not a business. So by nature, legal profession is not a business, but a noble profession whose dignity is to be maintained by the rules of professional ethics. So by default, by nature, legal profession is not business, so rules of business world, profit making rule and others shall not apply. Legal profession is not a business. It is a noble profession. We are helping others get justice. So its intent is noble profession. So whose dignity is to be maintained. Its dignity is important to be maintained by the rules of professional ethics. Okay, so this is the nature of professional ethics. Nature. Okay, not a business. Nature. It is a noble profession. Dignity is to be maintained. It is a noble cause, not a business. Noble cause. That is why rules of professional ethics are very helpful. Question number 42 is what is the position of an advocate? So, position of an advocate. An advocate is an officer of the court, and court acts on the statements of the advocates. So an advocate is an officer of the court, and court acts on the statements of the advocate. It is the duty of the advocate to assist the court in the due administration of justice. So what is the position of advocate? Where do advocates stand in the complete system of court? So an advocate is an officer of court. So in context of court, an advocate is an officer of court, and court acts on the statements of an advocate. So advocate is an officer of court, officer gives statements to the court, and court acts on the statements of its officer, that is its advocate. It is the duty of an advocate. The advocate is duty bound to assist the court in the due administration of justice. So what is the duty of an advocate? The duty of an advocate is not only to give justice to his only client. He is duty bound to assist the court in reaching a proper justice, to be able to administer the correct justice. So court is duty bound to assist the court in the due administration of justice. This is the position of an advocate. He is an officer of the court. His statements are helping courts to act, and his duty is to assist court in due administration of justice. Question number 43. Why an advocate should pay respect to the court? Why do an advocate is required to pay respect to the court? An advocate is like a judge himself, an officer of a court, and an integral part of the judicial machine. So he is very important, integral part of the judicial machinery. He is officer of the court. He is a judge for himself. The legal professional consists of the bar as well as the bench, and both have common aims and ideals. So bar and bench means the judges who are taking the decision. So both bar and bench have common aims and ideals. What is the common aim and ideal? To administer justice. So bar has the aim of administering justice. court or bench has the aim of administering justice. They have common aims and ideals. In theory, it is the king or sovereign who presides in the court of justice, and the judge is merely the mouthpiece and representative of the sovereign. So, in theory, it is the king or sovereign who presides in the court of justice, and the judge is merely the mouthpiece and representative of the sovereign. So, advocate is sovereign, and judge is only the mouthpiece. He is only speaking out what the advocate suggests to speak out, and representative of the sovereign. Respect shown to the court is therefore respect shown to the sovereign, whose representative the judge is. So judge is the representative of sovereign, and respect to court is respect to the sovereign. Not only litigants and witnesses, but the general public will get their inspiration in time in respect from the example of advocates. So from the example of advocates, from the example of giving respect, not only the litigants and witnesses will get inspired, but even general public will get inspired. So an advocate, representative of a bigger system of justice, okay, giving respect for the justice, the king, the sovereign justice. And if his behavior is good, if he is respectful, then the clients who are along with advocate, they will also be respectful. The witnesses who are presented on in the court, they will also be respectful, and even general public will be respectful for the court, for this complete system. So that is why they give respect to the court. So the court, so the advocates give respect to the court because this respect is essential for maintaining the dignity and decorum of the court. This respect is essential for maintaining the dignity and decorum of the court, ensuring that proceedings are conducted in an orderly and fair manner. So this will help ensure that proceedings are conducted in an orderly and fair manner. That is why this is important. Next is question number 44. What are the duties and obligations of an advocate towards his client? What are the duties and obligations of an advocate towards his client? Okay, so this was about court. Now we are about clients. Advocate is bound to accept any brief. Advocate is bound to accept any brief, not to withdraw from engagement. Okay, he cannot withdraw from engagement. Not to accept a brief in which he will be a witness. So he himself cannot be a witness. Then to disclose the facts likely to affect the client's judgment in engaging him. So he is bound to disclose the facts likely to affect his client's judgment in engaging him. Okay. To uphold the interest of client, he has to uphold the interest of client. To conduct the case so that it does not lead to conviction of innocent. So that is also the duty of an advocate towards the client, that innocent should not be convicted. Not to commit breach of an obligation imposed by section 126 of the Evidence Act. To have the fee based on the valid contract. There should be valid contract of fees. Not to bid or purchase property sold in execution of a decree. So he will not bid or purchase property sold in execution of a decree. He will not act to bid or purchase property sold in execution of a decree. And to keep the accounts of the client money. He will keep proper account of client's money. So let's take simple ones and take it. Let's go through duties and obligations of advocate towards the client in simple language first, and then rush this up again. In simple language, we have to draft our answer around confidentiality, loyalty, diligence, competence, communication, honesty, respect, advocacy. So first, confidentiality. Obviously, information should be kept confidential and not disclosed to any third party. Loyalty. must act in the best interest and without conflict. There should not be conflict of interest with the client. It has to be ensured that client's rights are protected. Then diligence must handle case with care, attention, dedication. Competence. Advocate must possess necessary knowledge, skill and expertise to handle client's case effectively. So this is an obligation that he should be competent. He has necessary knowledge and skill and expertise. Communication. He must communicate with the client, inform client about the progress of case, explaining legal options, potential outcomes clearly and promptly. So client should be informed these are potential possibilities, the outcomes of the case. And at each stage, what is the stage of progress, he should communicate to the client. Honesty. The advocate must be honest and transparent with the client, providing realistic expectations from the case, avoiding any misleading information. Then he should respect the client, respectful, courteous towards the client. Then advocacy. Advocate must represent the client's case zealously within the bounds of the law, advocating the client's rights and interest. So now let's go back what is written here. Advocate is bound to accept any brief. So brief means information which the client will share with advocate. So he is bound to accept any brief. Not to withdraw from engagement. He cannot withdraw from engagement. Not to accept brief in which he will be witness. So if he himself will be witness, then he will not accept the brief from the client, information from the client, facts and other information from the clients. Next is to disclose the facts likely to affect the client's judgment. So he will disclose the facts which will affect his client's judgment in engaging him. So suppose he is interested in the case in any way, then he will disclose those facts to the client, because then client may not want to engage such an advocate. Okay, so if an advocate has any such information which may affect client's decision to appoint this advocate as client's advocate, then that fact be disclosed by the advocate himself. Then to uphold the interest of the client, the advocate has to uphold the interest of the client. Then advocate has to conduct the case so that it does not lead to conviction of innocent. Case should be handled in such a way that innocent should not be convicted, not to commit breach of an obligation imposed by section 126 of Evidence Act. So Evidence Act should not be breached. To have the fee based on valid contract, there should be valid contract of fees, not to bid or purchase property sold in execution of the decree. So any decree is passed, then he will not purchase the property sold in execution of a decree. He will not bid even there. To keep accounts of clients' money. So he will keep proper accounts of clients' money, and in simple language, he will he will maintain confidentiality. He will maintain loyalty towards clients' interest, avoid conflict of interest. He will act diligently, presenting client's case properly with complete dedication and attention. He should be competent. He should have proper knowledge and understanding of law and expertise, and he should be competent, must possess necessary skills, communicate. He must communicate client. He should keep client informed at each stage of progress and potential outcomes. He should be honest and transparent with the client and provide realistic expectations. He should be respectful, courteous, and he should represent the client's case zealously within the bounds of law. Okay, so these are the various duties and obligations of advocate. Next is question 45. What is the importance of lawyers in legal profession? So in legal profession, what is the importance of lawyers? Lawyers provide legal knowledge to the litigants. So legal knowledge is provided to the litigants. Litigants are informed that this is the law of the country. So legal knowledge is imparted. The next is help in administration of justice. They are helping court, they are helping the judge in administration of justice. Then they are officers of the courts. The next is they ensure fair trial. They provide fair trial. The next is defend rights of the citizens. They defend rights of the citizens. Then help in reforming law. They help in reforming law through judgments, through practical scenarios. Law is reformed and refined. So these are the various important things. This makes the advocate, lawyers very important in the legal profession. So let's repeat: legal knowledge to the litigants, help in administration of justice, ensure fair trial, defend rights of citizens, help in reforming law. So let's explore in simple language, in simple terms, if we talk about importance of lawyers in legal systems. So these can be pointed out in advocacy, counsel, justice, specialization, ethics. So they provide advocacy, they represent clients in legal disputes, ensuring rights and interests are protected. Counsel, they provide legal advice, helping individuals, businesses understand and navigate complex laws. Laws are very complex, so they help clients and businesses understand and navigate through complex laws. And then justice, they assist in the administration of justice, they help courts in administration of justice. Specialization, they bring expertise in various areas of law such as criminal laws, corporate laws, family laws, intellectual property laws. So they bring specialization. And they bring ethics. Lawyers are bound by professional ethics, ensuring integrity and accountability in legal processes. So these are the various ways, and these are the various things which makes advocates, which makes lawyers very important in the legal profession. And here it is written: legal knowledge to the litigants, help in administration of justice, ensure fair trial, defend rights of citizens, and help in reforming law. Okay. Next is 46. What qualities must be possessed by an advocate in order to be a successful advocate? What are the qualities which an advocate should possess? Number one is hardworking, devotion, and good dealing with the clients and judges. He should be hardworking. He should have devotion. He should have good dealing with the clients and judges. Second is good command over language, good voice, good power of expression, good knowledge of law. So he should have good knowledge of law. He should have good voice. He should have good power of expression. He should have good knowledge. He should have good command over language. Next is methodological preparation. He should be systematic. He should be organized. He should have a methodological preparation of the case. The next is knowing the art of citation of cases. He should be able to cite the cases, past judgments. So he should know the art of citation of cases. Having acquaintances with the human nature and human motives. He should have acquaintance. He should have understanding of the human nature and human motives. Then man of integrity. Advocate should be a man of integrity and man of character. He should possess tenacious memory. He should have very good memory. He should have very good memory. Mannerism code. He should have code mannerism. Not to interrupt the judges. He should not interrupt the judges. And he should have good dealing with the client. He should have good dealing with the client. These are the qualities which must be possessed by a lawyer in order to be a successful lawyer. Hard work, devotion, good dealing with the clients, and good dealing with the judges, good command over language, good voice, powerful expression, good knowledge of law, methodical preparation of the case. He should know the art of citation of cases. He should have acquaintance of human nature and human motives. He should be a man of integrity and character. He should possess tenacious memory, very good memory. He should have court mannerism. He should have understanding of mannerism in court. He should not interrupt judges and should have good dealing with the clients. So these are the qualities of a lawyer in order to be a successful lawyer. What is the professional misconduct? What is a professional misconduct? Dereliction of duty by an advocate towards the client or case. So if there is a breach of duty towards the client, or towards the case. So if breach of duty towards the client or breach of duty towards the case, dereliction of duty of an advocate towards the client and or case causes professional misconduct. Dereliction means failing to perform legal duties diligently. So if he fails to perform his legal duties diligently towards the client or towards the case, then that amounts to professional misconduct. And professional misconduct includes other things also, like one is dereliction of duty, failing to perform legal duties. Another is professional negligence. So if he is negligent, he is providing substandard legal service, or he is misappropriating, misusing client funds, misappropriating client's property or funds, or he's changing sides, representing conflicting interests without consent, or he's contempting the court with disrespecting the court procedures or orders, or if he's furnishing false information, providing misleading or false information to the courts, or his behavior is improper, not he's acting in a manner unbecoming of an advocate. So all these amounts to professional misconduct, dereliction of duty by an advocate, falling short of performing duties of an advocate towards client or case. What do you mean? Say question 48. What do you mean by professional or other misconduct? What do you mean by professional or other misconduct? What do you mean by professional or other misconduct? Okay. Misconduct, whether in professional capacity or in other capacity. Professional or other misconduct. Misconduct means whether in professional capacity or in other. So this is similar answer. What do you mean by professional or other misconduct? Misconduct, whether professional capacity or in other capacity. So misconduct includes many things like neglect of duty, misuse of client funds, conflict of interest, contempt of court, false information, unethical behavior. There are many uh, misconducts provided. So misconduct, whether professional capacity or in other capacity. Then question number 49. What do you mean by bar bench relation? What do you mean by bar bench relation? Bar and bench play an important role in the administration of justice. The judges administer the law with the help of lawyers. The lawyers are the officers of the court. They are expected to assist the court in the administration of justice. Actually, lawyers collect materials relating to the case and thereby assist the court in arriving at the correct judgment. The legal profession has been created not for private gain but for public good. So we can design our answer: bar and bench relation both act together. Advocates are officers of court. They assist court in administration of justice. They collect material of the cases. They present material of the case. What is the intent of presenting the material of the case? That correct judgment can be imparted. The legal profession has been created not for private gain but for public good. That is why it is different from business. It is not a profit motive. Ultimately, motive is the administration of justice. Justice should happen. This is the motive. They are assisting, helping clients to reach justice. What do you mean by contempt of court? Question 50. Any conduct that tends to bring the authority and administration of law into disrespect or disregard, or to interfere with or prejudice parties, litigation, or their witnesses during the litigation. So let's simplify. In simple language, contempt of court refers to behavior that disrespects or disobeys the authority, justice, and dignity of the court. Okay, disrespects or disobeys the authority, justice, and dignity of the court. It can be classified into two types. One is civil contempt, another is criminal contempt. So, civil contempt is willful disobedience to any judgment, order, direction, or other processes of the court, or willful breach of an undertaking given to the court. For example, not complying with court's order. This is a civil contempt. Then another is criminal contempt, actions that obstruct or interfere with the administration of justice, that is like scandalizing the court, prejudicing or interfering with legal processes, interfering with administration of justice. So in many ways, a court can be disrespected and disobeyed, and all these amount to contempt of court. So here written is any conduct that tends to bring the authority or administration of law into disrespect or disregard, or to interfere with or prejudice parties, litigation, or their witnesses during the litigation, disregard or interfere with or prejudice parties, litigations, or their witnesses during litigations. So, in any way, disrespect or disobedience of authority, justice, and dignity of court. It can be civil contempt, like not complying with court order, or it can be criminal contempt like scandalizing the court, or prejudicing or interfering with the legal processes, interfering with the administration of justice. Next is question 51. What do you mean by civil contempt of court? Then we will have criminal contempt of court. We have already covered right now. Willful disobedience of any judgment, decree, direction, order, writ, or any other process of the court, of willful breach of undertaking given to the court. Any undertaking given to the court is breached. If an undertaking is given that these people will be paid, this check will be cleared, and that is not done, so that amounts to civil contempt of court. Disobedience, willful disobedience of judgment, willful disobedience of decree, willful disobedience of direction, willful disobedience of order, willful disobedience of writ, willful disobedience of any other process of court, willful breach of an undertaking given to the court. All these amount to civil contempt of court. Then question 52 is, what do you mean by criminal contempt of court? So, the publication of any matter or the doing of any other act whatsoever which scandalizes or tends to scandalize or lowers or tends to lower the authority of any court. So, any publication which can scandalize or lower the authority of court, or its intention, it may tend to scandalize or lower any authority of the court, then this amounts to criminal contempt of court. Or prejudices or interference or tends to interfere with the due course of any judicial proceeding. So, normal due course of proceeding is prejudiced in any way. Normal due course of any proceeding is interfered with. Then it will amount to criminal contempt of court. And lastly, interferes or tends to interfere with or obstruct or tends to obstruct the administration of justice in any manner. So if administration of justice is obstructed, interfered with, then or it tends to in future it will tends to obstruct or interfere with administration of justice, it will be criminal contempt of court. Three things are either publication which scandalizes or lowers authority of court, or it interferes or prejudices due course of any judicial proceedings, or at the end it interferes or obstructs administration of justice. All this amounts to criminal contempt of court, while civil contempt was not following the order or not breaching with the undertaking given to the court. So that was civil contempt of court. Okay, so next we move to page 6. We have what are the examples of contempt of court. So here we cover certain examples of contempt of court. So first is abusing, assaulting, or obstructing a process served in the execution of his duties pursuant to the court's order among the contempt amount to contempt of court. So what is contempt of court? Let's complete this. Similarly, interference with the receiver appointed by court, casting as persons on counsel which tend to deter him from discharging his duties. All these amounts to contempt of. Let's take some simple language examples of contempt of court. Like if we ignore orders passed by the court has given some ruling or direction, and we are not agreeing to that, then we are disrupting behavior we are giving a disrupting behavior in court, like shouting, and the court is asking you to reduce voice and you are not listening, so that may amount to contempt of court. Refusing to sit down when court judge asks you to sit down and you are not sitting down, or using a disrespectful language, then this is also an example of contempt of court. Next is publication of prejudicial material. So if any media publication is done which can affect the case, then that is also amounting to contempt of court. Interfering with witnesses. If witnesses are intimidated, or if bribe is offered to witnesses, or in any way witness is prevented from giving honest testimony, so all these amount to contempt of court. Or refusing to testify means when you are summoned to answer some questions, then you are not doing that. When you are legally obligated to answer certain questions and you are not answering those questions on summon, then also you are contempting the court. So now back to this answer. Here it is written: abusing, assaulting, or obstructing a process served in the execution of his duties pursuant to court's order amount to contempt of court. Similarly, interference with the receiver appointed by the court. Court has appointed a receiver and you are interfering with him. Casting as persons as counsel which tend to deter him from discharging his duties. What is the meaning of court for the purpose of Contempt of Courts Act 1971? So now what we were discussing was 1961. Advocates Act was 1961. After 10 years, what we have after 10 years, we have Contempt of Courts Act 1971. 1971, after 10 years, we have Contempt of Court Acts. And what is the meaning of court for the purpose of Contempt of Courts Act? Only for the purpose of Contempt of Court. What is the meaning of court? Can all tribunals be covered, or only High Court, Supreme Court be covered, or nothing be covered? So, what is the meaning of court only for the purpose of contempt of court under Contempt of Courts Act 1971? Answer is, according to Stephen, in every court there must be at least three constituent parts: the actor, reus, and judge. The actor or plaintiff who complains of an injury done, the reus or defendant who is called upon to make satisfaction of it, and the jurex or judicial power which is to examine the truth of the facts and to determine the law arising upon that fact, and if any inquiry appears to have been done, to ascertain, and by its officers to apply the remedy. Okay. So question is, what is the meaning of court for the purpose of Contempt of Courts Act 1971? We will see two answers. First is this, what is written here. What is written here is simply court means where there are three parties to it, three constituents. Number one, the plaintiff. Number two, the defendant. Number three, the judicial system, judicial power. Okay, this is what a court is suggested here. That meaning of court is for the purpose of Contempt of Courts Act means there should be three constituents, and that is court for the purpose of Contempt of Court Act. However, I read an answer online which provides that under the Contempt of Courts Act 1971, the term court refers to any court established by law for the administration of justice, including Supreme Court, High Courts, and subordinate courts. So courts include Supreme Court, court includes High Courts, court includes subordinate courts. Any system of law which is established for administration of justice is referred to as court. And since any, and here the word is including, so every court which we understand as a court is a court. And even tribunals and others, how will we know whether those are courts or not? So if there is an establishment for the purpose of administration of justice, then it is a court. So coming back to what is written here, according to Stephen, every court there must be at least three constituents part. First one part is the actor, reus, and judge. The actor, Means three part: the actor is there, the ruse is there, and the judge is there. These are the three constituents. So first is the actor. Actor means plaintiff who complains of an injury done. Then ruse. Ruse is defendant who is called upon to make satisfaction of it, whether the injury has been done or not. He will defend his case. Defendant. Ruse. First one was actor. And third is jurex, judicial power, which is to examine the truth of the facts. So truth will be examined by judicial power and to determine the law arising upon the facts. And if any injury appears to have been done, to ascertain and by the officers to apply the remedy. So if truth will be of the facts will be determined, and if it is found that the injury has been done, then the remedy will be applied. So this judicial power is there. Judge, actor, ruse, and judge, all three comprise that is called court. And it is a inclusive definition that it is an administration by law for the it is an established by the law for administration of justice, and it includes Supreme Court, high courts, and subordinate courts. Next is question 55. What do you mean by administration of justice? What do you mean by administration of justice? Okay, so administration of justice includes all the functions of a judge, whether administrative, adjudicatory, or any other necessary for the administration of justice. So, simply put, all functions of the judge are part of administration of justice. Everything a judge does forms part of administration of justice, including administrative act, including adjudicatory act, or any other thing necessary for the administration of justice done by the judge. So from common sense parlance, administration of justice is very wide term. Administration of justice will include every process and every institute involved in upholding and enforcing the rule of law in a society. So every process, every institute is covered in the administration of justice for enforcement of rule of law in society. So courts are included, law enforcement like police and other agencies are included, legal procedures, methods, processes, trials, justice, evidence collection, legal representation, trial proceedings, everything is covered. Correctional institutions like prison, probation systems, these are covered in administration of justice. Legal framework, the laws, regulations, legal principles guide functioning of justice system. So complete written law. This is all comprising administration of justice. Overall, everything is for the purpose of administration of justice, but here answer is all about functions of a judge. So it says all the functions of a judge. Administration of justice includes all the functions of a judge. So limited answer is given whether administrative functions are performed by judge, adjudicatory functions are performed by judge, or any other necessary for the administration of justice. What are the two essentials of civil contempt of court? So essentials means if I am going to court that see a civil contempt of court has happened. So what two basic things which I need to prove that see these two things has happened and hence civil contempt of court has happened. So number one essential is there is disobedience of the court decree etc of the court or breach of undertaking given by the court. So an undertaking was given to court which is breached, or the court has given some order or decree which is disobeyed. Number two thing is disobedience or breach is willful. So this has happened and this has happened willfully. So if it is proved that disobedience or breach has happened and that has happened willfully, if these two conditions are fulfilled, disobedience has happened, breach has happened, and these both or any has happened willfully, then it will amount to civil contempt of court. These are the essentials for a civil contempt of court which must be proved. What are the essentials of criminal contempt of court? For criminal, we will see number one, publication or other act. There is an act which will be highlighted that see this has happened, this is published, this act is done. Then number two is scandalizing or lower the authority of the court or interfering with the judicial proceedings or administration of justice. So one is that certain publication or certain act is highlighted. See, this has happened, and as a result of happening of that, what has happened? This has happened, and as a result of happening of that, what has happened? So these are proved in criminal contempt of court. That see, there is publication, this is an act done, and as a result of that, scandalization of authority of court has happened, lowering of authority of court has happened, or judicial proceeding has been interfered because of that act or publication, or administration of justice has been interfered because of that publication or act. So all this has happened. So two essentials are publication or act, and it has caused something: scandalization, lowering authority, interfering judicial proceeding, interfering administration of justice. Question 58 is, what are the duties and obligations of an advocate towards the court? Towards the court. How an advocate is duty bound and obligated towards the court. So he has following duties and obligations. Number one is to file the suit firmly. He has to file the suit firmly. To maintain the dignity of the court. He will maintain the dignity of the court. Not to influence the decision of the court. He will present the facts. He will argue well for his client, but he will not influence the decision of the court. To prevent his client from resorting to unfair practices. He will prevent his client from resorting to unfair practice. He will to appear in the prescribed dress. He will wear proper uniform, court uniform. So he will appear in the prescribed dress. This is his duty and obligation towards the court. The next is not to appear in court which is related to him. So if any court is related to him, then he will not appear in that court. Not to appear in court which is related to him means his relative is a judge. So next is not to wear bands or gowns in public places. He will not wear bands or gowns in public places. So he will wear his bands, he will wear his gown only in court and not in public places. The next is not to appear in the court of which he is a member of the executive committee. So if he is a member of an executive committee of a court, then he will not appear before that court. And not to plead a case in which he has pecuniary interest. So if he has a pecuniary interest in a case, then he will not plead in that case. So these are the duties and obligations of an advocate towards the court. Let's repeat and then we will simplify also. To file a suit firmly, to maintain dignity of court, not to influence decision of court, to prevent his client from resorting to unfair practice, to appear in the prescribed dress, not to appear in court which is related to him, not to wear bands or gowns in public places, not to appear in the court of which he is a member of the executive committee, and not to plead a case in which he has pecuniary interest. So let's simplify. Under Advocates Act 1961 and for Contempt of Courts Act was 1971 after 10 years. So Contempt of Court was 71 and Advocates Act is 1961. So advocate has several duties. In simple words: respect for the court, integrity and honesty, fair conduct, promptness, professionalism, confidentiality, non-interference. These are the basic points around which answer can be prepared. Respect for court, maintain decorum and respect towards the court, ensuring that behavior and language uphold the dignity of judiciary. Integrity and honesty, conduct oneself with honesty, not misleading the court or allowing untruth to be presented. Fair conduct, avoid using illegal or improper means to influence court decisions. Promptness, attend court promptly and be well prepared for cases respecting the court's time. Professionalism, adhere to professional etiquettes and ethics, presenting arguments in a clear, concise, and respectful manner. Confidentiality protect any privileged communication between the advocate and the client that could be relevant to the court. Non-interference: do not interfere with the court's proceedings or show disrespect through actions or comments. So, going back to what is provided here, to file a suit formally to maintain the dignity of the court, not to influence decision of the court, to prevent the client from resorting to unfair practices, to appear in the prescribed dress, not to appear in the court which is related to him, not to wear bands and gowns in public places, not to appear in the court of which he is a member of the executive committee, not to plead a case in which he has pecuniary interest. So simplified: respect for court, integrity, honesty, fair conduct, promptness, professionalism, confidentiality, non-interference. Next is question number 59. Question number 59 is, what are the duties of an advocate towards his colleagues? So what are the duties of an advocate towards his colleagues? We understood duties towards client, duty towards court, and now we are understanding duty towards his colleagues. I think now we are very well familiar with what is going on. So we will speed up, rush up. Okay, context is very well established, that few words are there around which we can draft our answer easily. So duties towards colleagues is, an advocate shall not solicit work or advertise his position or association with any person or organization, or with any particular cause or matter, or that he specializes in any particular type of work, or that he has been a judge or an advocate general. So, an advocate shall not solicit work or advertise his position or association with any person or organization, or with any particular course or matter, any particular cause or matter, or that he specializes in any particular type of work, or that he has been a judge or an advocate general. So he will not do all these things. Okay, if he was a judge, then he will not advertise. He will not solicit clients that he was a judge, so he has an influence. He has specialization in certain matters only. So he is the one should be referred to for these kind of matters. So he will not advertise about himself or his organization in any way, or his specialization in any way. Then, an advocate shall not permit his name to be used in aid of or to make possible the unauthorized practice of law by any agency. He will not allow any agency to use his name for any unauthorized practice of law. He shall not act, he shall not accept a fee less than a fee taxable under the rules. So, he shall not accept a fee less than a fee taxable under the rules when the client is able to pay the same. Okay, he shall not accept a fee less than the fees taxable under the rules when the client is able to pay the same. He shall not enter appearance in any case in which there is already a wakalatnama or memo of appearance filed by an advocate engaged for a party except with his consent. So if he is taking a case, then if there is already existing a wakalatnama or memo or a random of appearance, then he cannot accept that case unless the advocate with that present wakalatnama or memo of appearance give his consent that this can take over the case. So only with the consent of current advocate he can do so. So these are the duties of an advocate towards his colleagues. Before reading this answer again, let's put in simple language. So duties toward colleagues can be courtesy and respect, fair competition, confidentiality, support and cooperation, professional integrity, constructive feedback. So like courtesy and respect, treat fellow advocates with courtesy and respect regardless of their seniority or position. Fair competition, engage in fair competition without resorting to unfair practices or denigrating colleagues. Confidentiality, respect confidentiality of information shared by colleagues during professional interactions. Support and cooperation, offer support and cooperation when necessary, fostering a collaborative professional atmosphere. Professional integrity, uphold professional integrity by not engaging in or tolerating dishonest or unethical behavior among colleagues. Constructive feedback provide constructive feedback and mentorship to junior advocates, helping them grow professionally. And here the answer written is: an advocate shall not solicit work or advertise his position or association with any person or organization, or with any particular cause or matter, or that he specializes in any particular type of work, or that he has been judge or advocate general. So he will not advertise like this, and he will not solicit work. An advocate shall not permit his name to to be used in aid of or to make possible the unauthorized practice of law by any agency. He shall not accept a fee less than a fee taxable under the rules when the client is able to pay the same. He shall not enter appearance in any case in which there is already a wakalatnama or memorandum of appearance filed by an advocate engaged by a party except with his consent. What are the duties of an advocate towards opponent? So, towards an opponent, there are also some duties. An advocate shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by the advocate except through that advocate. An advocate shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by an advocate except through that advocate. An advocate shall do his best to carry out all. Let's first simplify this answer. In simple language, duty towards opponent will require to maintain professionalism and integrity in the legal profession. So which these includes like fair dealing. Treat the opponent with respect and fairness, avoiding any tactics that would unjustly harm them. Number two is integrity. Do not mislead or deceive the opponent or their counsel with false statements or evidence. Courtesy. Maintain a courteous and respectful demeanor even in the face of conflict or disagreement. Professional conduct. Engage in fair competition and do not resort to personal attacks or unethical behavior. Confidentiality. Respect the confidentiality of information and means respect the confidentiality of information shared during negotiations or legal proceedings. Honesty. Be honest in your dealings, ensuring that any representations made to the opponent are truthful and accurate. Honesty. So, fair dealing, integrity, courtesy, professional conduct, confidentiality, honesty. And now let's get back what is written here. So, and here it is written regarding duties towards opponent: an advocate shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by an advocate except through that advocate. An advocate shall do his best to carry out all legitimate promises made to the opposite party, even though not reduced to writing or enforceable the rules of under the rules of court, and not to engage in discussions about the subject matter of the dispute with the opposite party without notice to his counsel. So it is more about interaction with opposite party. So opposite party means in context of opposition, our advocate will not contact opposite party directly. Okay, our advocate will not try to influence opposite party directly. Our advocate will not do anything directly with opposite party. Our advocate will do through his advocate and not directly. So our advocate will talk to opposite party's advocate. Okay, so now again coming back from the opponent point of view, our advocate not to engage in discussion about the subject matter of dispute with the opposite party without notice to his counsel. So, without notice to opposite party's counsel, he will not interact with the opposite party. Our advocate will not interact with the opposite party. Then, Again, an advocate shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by an advocate except through that advocate. Similar point, बिल्कुल exactly same point is there what we just read. Will not approach directly, will only approach with information to advocate, knowledge of advocate. An advocate shall do his best to carry out all legitimate promises made to the opposite party, even though not reduced to writing or enforceable under the rules of court. So if advocate has made any commitments to opposite party, then those will be fulfilled. And any interaction on subject matter with the opposite party should happen with notice to opposite party's counsel. What are the powers of central government to make rules? Question number 61. What are the powers of central government to make rules under the Advocates Act 1961 for the proper enforcement of its provisions? So, according to section 49A, subsection A, 49 subsection, no. According to section 49A, subsection 1, okay, we are talking about powers of central government to make rules under the Advocates Act 1961 for the proper enforcement of its provisions. So, according to 49A, subsection 1, the central government may by notification in the official gazette make rules for carrying out the purposes of this act, including rules with respect to any matter for which the Bar Council of India or State Bar Council has power to make rules. So, under the provisions of Advocates Act, central government has wide powers to make rules for carrying out the purposes of the Advocates Act, and these powers are given under section 49A, and these powers even grow beyond powers of Bar Council of India and powers of State Bar Council. So central government is powered to make rules including in respect of matters where Bar Council of India or State Bar Council has power to make rules. So even on those matters central government has power to make rules. And also anything it can make rules, anything to carry out the purposes of this act, and all this power is given to central government under as per section 49A of the Advocates Act 1961. So rules are made by notification in the official gazette. Once rules are made and notified, then that becomes a law. Okay, and anything, one thing is clear, it should be intended for the purposes of this act only, and then they have power. They can make rules even on matters in which the powers are vested with Bar Council of India and or State Bar Council. So rules can be made on those only. Ultimate purpose is for the purposes of this act. Central government has power under which section of Advocates Act 1961? Under section 49A. Okay. Question 62. Trace the development of legal profession during British period. Okay, during British period, how did legal profession develop during British period? Now we are going back. In early days of British period, the legal profession was not paid due attention and it was not well organized. So earlier it was not well organized, it was not paid any due attention. In pursuance of the powers conferred by Regulating Act 1773, so we are now back in 1700s, 1773, not 19s, not 18s, even earlier, 1773. Regulating Act 1773. Okay. In pursuance of powers conferred by Regulating Act 1773, the British government by a charter of 1774 empowered the Supreme Court to approve and enroll advocates and attorneys at law. So Supreme Court had power before Bar Council. Supreme Court had power to approve and enroll advocates plus attorneys at law. Then this was with Regulating Act 1773, British government by Charter of 1774 empowered Supreme Court. The Supreme Court had power to remove any advocate and attorneys at law. They were authorized to appear and plead and act for the suitors of Supreme Court. Indian legal practitioners were not authorized to appear before the Supreme Court. So this is important that only advocates and attorneys in at law were authorized. They could have been removed by Supreme Court, and Indian legal practitioners were not authorized to appear before Supreme Court. The High Courts not established by Royal Charter were empowered by Legal Practitioners Act 1979 to make rules as to qualification and admission of proper persons to be advocates of the court. So, the High Court not established by Royal Charters were empowered later on. When later on? In 1979. So 1700s went by, 1800s went by, 1900s almost went by in 1979. So almost by the end of 1900s. There is an act, Legal Practitioners Act, which empowered High Court, and only those high courts not established by royal charters, only those high courts were empowered to make rules to the qualifications and admission of proper persons to be advocates of the court. So this is the history of development of legal profession during British period. Earlier it was not well regulated, not well organized. Indian advocates were not even allowed, Indian legal practitioners were not even authorized to appear before Supreme Court. Only advocates and attorneys at law were authorized to plead on suits before Supreme Court, and Indian legal practitioners were not authorized until this changed after 1979, and that too only in high courts not established by royal charters. 63. Question 63. What was the reason for constituting Indian Bar Committee? 1923. Okay. So what was the reason for constituting Indian Bar Committee 1923?